Welcome to CLESTalk, Law for Sustainable Cities, a podcast that focuses on cities, law, and environmental sustainability. In this podcast, we venture into legal scholarship and research on sustainable urban development in South Africa. In this series, we will feature special guests and also host our CLES researchers. For those who may not know, CLES is a research chair under the National Research Foundation Research Chair Initiative and operates under the Faculty of Law of Northwest University. My name is John Rantlo, a postdoctoral research fellow at CLES and your host for this session. Today we have Professor Elmien du Plessis with us in CLES studio. Professor du Plessis is a professor at the Northwest University. And in our session today, our topic is urban land and expropriation of land without compensation. This episode explores the complex relationship between urban land and expropriation of land without compensation. Professor du Plessis, welcome to CLESTalk. We are really honored to have you in our CLES studios today. And I am not sure, just to start off, whether to call you your ladyship, as you are the acting judge of the High Court. So I'm not sure, should I?
Good morning, John. You should definitely not, because I'm here in my capacity as a legal scholar and academic at the Northwest University. But thank you very much for inviting me and for having me here.
Thank you so much for honoring our invitation. But that's one of the just points that I wanted to throw in there, that people should know that you are the acting judge. So just to start off, can you please provide a brief overview of your research on urban land and expropriation of land without compensation?
Yes, thank you, John. When you asked this question to me previously when we had a conversation, I was thinking, well, I don't really specifically deal with urban land. I know about urban land because I deal with property in general. And expropriation, of course, can happen on both urban and rural land. So when we had the conversations about the amendment of the Constitution and even now the expropriation bill, I was quite struck at how we only focus on the rural aspect of possible expropriation. And I just we can perhaps later clarify what expropriation without compensation may entail. But I think what specifically interests me in the South African context, and I think somebody like Mumdani, he also wrote quite a bit about this, I can never say that word, bifurcated state, or this, duality that we have between urban setting that's governed by a certain set of laws, and that's a colonial and apartheid land hangover, and a rural setting that's governed by, sometimes in, for instance, the former Bantustan areas with a different kind of law, and how expropriation might play out in these different settings. So that's definitely something that interests me, but also more specific, how we still have that pattern of people who have a rural home and an urban home and migrate between these two spaces, and the implications that might have for urban development and housing, but then also where expropriation will come in there. So my research is not specifically focused on urban land, but I do understand that our focus today will be on the impact of expropriation in urban land. But I just want to put that out there, that it's more of a broader, holistic view on the whole land reform situation.
So just to bring things into context, perhaps as a starting point, what is urban land use?
Yes, so urban land use looks at what actually happens on the land in urban areas, and what perhaps should happen on the pieces of land. What are the needs? Where should certain activities take place? That, of course, links in, but should not be confused with something like zoning, where zoning deals specifically with the specific permissions on a specific set or specific urban or property in the urban area. So land use refers to whether land should be used or is perhaps used for housing or for leisure or for manufacturing purposes. So that's what land use is about.
Quite interesting. And what are some of the current challenges facing the urban land use in South Africa?
If you drive through South African settings, you will see that we are still, in many places, very spatially divided. Our spatial layout of cities especially but also many towns still reflects the apartheid spatial land use, where the opportunities, are far removed from the people who need to be closer to the opportunities. So, for instance, if you drive to Johannesburg, on the outskirts of Johannesburg, you have a lot of lower income residential areas, while many of those people actually work more within the inner city of Johannesburg, so they travel a lot more. There's a lot of studies done, for instance, by SERI that shows that if you are unemployed and you live on one of these outskirts, also the informal settlements, the likelihood of you ever getting a job is quite low because you are far from the job opportunities. So I think the biggest challenge also from a land reform point of view is how do we get people closer to job opportunities so that those indignant people don't have to spend most of their days traveling to jobs and don't have to spend most of their income on the transport costs of getting into the city. I think those are, from a land reform perspective, quite a big challenge.
So just linked to that question, perhaps how can we address some of these challenges?
Yeah, so it's difficult to address it if you have already a city like Johannesburg who's well established, where the housing stock that's in the inner city is either unaffordable to people in that lower income bracket. In a perfectly functioning society, you would have social housing. To some extent, there are some social housing projects in Johannesburg. We know that there are also a problem with these social housing projects, but where the state subsidize housing for people who cannot afford housing in those areas. So in an ideal world, and that happens in many other countries, I think England is sometimes held up as a good example, where you have council housing, where the council provides housing and you pay what you can afford, or there are methods of working out how much rent you will pay. But to get housing stock closer to the inner city, that the state subsidizes in some ways so that it enables people to have access to housing closer to job opportunities. I must say the problem that we have at the moment in a place like Johannesburg, for instance, is that council outsourced this part of their functions in I think it was in the early 2000s to companies that does it on behalf of Johannesburg, and companies might have other goals than to provide housing as a municipality should, have. So those, I think, are complex challenges. But I think that in an ideal world, that would be a good solution. Yeah.
Thank you so much. Moving to the question of expropriation of land without compensation. This is one of the contentious issues in South Africa, as we have seen recently. But one may ask, what is expropriation of land without compensation? What does it entail? And what are your views, perhaps, on amending Section 25 of the Constitution?
Yes, so I think I always warn people that I am a legal scholar, so I am going to approach this from a legal perspective. But perhaps we should take a step back and look at what do we mean when we say expropriation without compensation, because I think a lot of the conversation is lost there, that we have different meanings to that. So I think for me the legal meaning is, can you expropriate, which is a specific legal mechanism, somebody's property without paying them anything? And I will park that there because that will link onto my views on Section 25. But I think often when people speak of expropriation without compensation, it's a catchphrase for when are we going to do land reform in general, while expropriation is a very small aspect of land reform. Or it can be a contestation on who does this land belong to. When we say things like you stole the land or the land is ours, I think that's also in that whole conversation. And those are very difficult and sometimes very uncomfortable conversations. So I want to put it out that I am aware of these other conversations taking place. However, as a legal scholar, I ask myself, okay, so expropriation, we learn in second year property law, is an original form of acquisition. And we also learn in second year property law that expropriation, because it's an original form of acquisition, the transfer of the land doesn't need the cooperation of the previous owner. So the state does not need any owners permission to be expropriated. I think that's important. And that the land will be transferred once all the legal requirements are met, usually on the date of the expropriation notice. Okay, so there's no contract that need to be signed. But then to make sure that the state does not abuse its power, our constitution says it must be for public purpose or in a public interest. So public purpose would be something like building a school, extending a road network, the Gautrain, for instance. There was a lot of expropriations for public purposes. It's a purpose that the whole public benefit from. And we say, John, if I'm going to expropriate a piece of your property in order to widen the road, it is something that's going to benefit the whole of society. And because it benefits the whole of society, we cannot expect you, John, to part with your property without any form of compensation. Otherwise, you will bear the brunt of this thing that we all will benefit from. So public purpose, always compensation paid. Public interest is an interesting thing. So that's something that the Constitution brought in by saying that interest includes land reform. So it is also possible that somebody's land can be expropriated to be transferred to somebody who's a beneficiary in terms of land reform. And then things can become a little bit muddy because there are various interests that need to be weighed up. We have an interest in ensuring that land reform happens and that it happens effectively and that it's not curbed by having to pay high prices for land. But we also have this owner who will be left without an asset and in many instances might have bought the property. I think 60% of land was transferred after 94, so it wasn't in terms of apartheid laws. And it might be unfair to leave this person without compensation because our compensation standard is just an equitable compensation. So that's just the bigger legal picture. Then when the conversation started, it became clear, but maybe there are instances where expropriating the property might be just and equitable if the owner receives little or even R0 compensation. But I think that's a very big but. It's not something that happens without thought. It's not something that can happen large scale. The state must still, when they want to expropriate your property, justify how paying very little or R0 compensation is just and equitable. So what came out in this, which I thought was interesting in the amending Section 25 conversation, we all know that 18th Amendment Bill lapsed, so it's no longer on the table for now in Parliament, or there's no process going on trying to amend Section 25, was that people started to talk, well, in what circumstance might it be just and equitable to pay R0 compensation, and that's now contained in the expropriation bill that we can talk about a little bit later. But then you ask me, what do I think about the amendment of Section 25? In the beginning, I was quite opposed to it because from an interpretation perspective, Section 25 provides a framework and it lays down the principles and the compensation principle. So our compensation standard is just and equitable. It's not market value. Nowhere does it say it must be full market value. It left it over to the executive and parliament effectively to be able to, within that what is just and equitable, move to think of instances where, less than market value, which was the norm before 94, may be paid. And I thought we haven't done enough work in terms of legislation. We do have the expropriation bill now, which is also a bit contentious. We can pick up on that, which in clause 12 sets out, which I think is good, on what instances they foresee, that compensation may be less than market value or nil. But ideally, and I still advocate for that, we need cases to go to court. Because as we teach our students in second year interpretation, legislation only gets interpreted once it is applied to a set of facts. And we've had very, very little cases in court about less than market value compensation or zero compensation. Although I can agree with the critics of Section 25 that some of those cases that did go to court, the court in many instances did revert back to market value. No? I always say it's a safe space because you've got case law to lean on. It's the way we were brought up to think about expropriation previously, before 94. And in that sense, the amendment that was proposed, I think that was not a very well worded or well thought out amendment, but that there might be some merit in clarifying some of these things in the Constitution. I can be open for that, but I think I've learned a lot during that process, that it's often not about the law, but about other political things that happen that drives the process. So I think I think one can have this conversation. I don't think the Constitution can never be amended. Section 74, I think, makes provision of 70. It's 74, 76, makes provision for how the Constitution can be amended. So it's possible to do that, and you should be able to do that. But I think it must be grounded in a little bit more substance, if I can call it that.
For now, you would argue that we should not amend Section 25, but rather whatever that needs to be explained further, it can be done through an act of parliament.
Yes, so we have the expropriation bill that sets out quite clearly the direction it wishes to go. I think it's a very good bill. There are some criticisms that I think is valid about definitions and other small things. But for instance, if I can just refer you to clause 12, it says here that, in certain instances, compensation may be, so it's not must be, it may be. So it gives direction to the court. Perhaps it gives a little bit of permission for the court to be more adventurous. It says that it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest. So there's that safeguard there, having regard to all relevant circumstances. And then it lists certain instances where it thinks it may be just and equitable. And I think for purposes of this urban context, C is quite important, notwithstanding registration of ownership in the Deeds Registries Act, where an owner has abandoned the land by failing to exercise control over it. We know we've got a lot of abandoned buildings in Johannesburg, so they say, well, maybe if those buildings are abandoned, we can expropriate it and we don't have to pay the owner because he's not taking care of the property anyway. Or where organ of state holds land, we have a lot of that kind of land in Cape Town, for instance, close to the waterfront. Transnet owns a lot of land in that area, so if Transnet is not using that, then maybe the Department of Land Reform or whoever, housing, should be able to expropriate that to build houses. So I think that makes it all physically a risk. Where there's a physical risk in the property, then maybe the state can expropriate there. So I think it just gives an indication, and it gives a little bit more flesh to Section 25 on what it can possibly mean to pay just and equitable compensation. So if this bill goes through, I think it's a big step, and I think any sort of refining work should be done in court on a specific set of facts. I think our eviction law gave a lot of content to what it is to be just and equitable eviction, right? So it must be just and equitable, and through case law we've developed what that means, and I think something similar can happen in the expropriation sphere.
Thank you so much, Elmien. So in your submissions to the Parliament Constitutional Review Committee recently on land expropriation without compensation, one of the things that you stated is that one of the pertinent questions that needs to be asked is what will happen to the urban land question, and how do we then deal with the tenure upgrades in both the urban and rural areas. Can you perhaps just share with our listeners on how these issues can be tackled with effectively?
Yes, so I think a lot, as I said in the beginning, a lot of our focus is on rural land. I think a lot of people who are opposed to the expropriation bill and are very vocal about it are our farmers. You hear about food security, etc., etc. While ever since the end of apartheid, there's been a great urbanization. The need for urban, there are no jobs in the rural areas. Farms expanded and got bigger with fewer farmers in the rural area. So there are fewer work opportunities. We know about the problem with our little towns in South Africa that's being depopulated and dying out, in a sense, some of them. And the bigger need is in the urban areas where there are job opportunities, good school opportunities, etc., etc. And we often do not include that in our conversation. I blame it on the fact that we have a Department of Housing and a Department of Rural Development and Land Reform. So each department is responsible for their own portfolio, and there's not always an overlap or communication between the two. And also, especially in light of the fact what I said earlier on, that we do have a lot of people who have maybe a home that's not in the city, and that there's still some form of migration. So that's the one thing. The other thing is a lot of people who live in informal settlements, they don't have secure tenure. We have 60% of South Africans live what we say off register. So their rights are not registered or recorded in any way. Those are not only people living in so-called communal areas, it's also people who live in backyards, which we find a lot. We had a lot of that. A lot of the problems there came out during COVID, when people were no longer what we call backyard dwellers. They were no longer able to pay the rent during COVID. They were evicted. They moved onto state land. We saw the dramatic evictions from state land then. So I think that's a very big problem. People who live, for instance, in backyards, their rights are not that protected. We have people in informal settlements who don't have any of their tenure rights protected. And then there are actually quite a lot of people still in places like Soweto who lives in terms of PTOs that were somehow upgraded or not. That's permission to occupy. That's what people lived with. It's permits. And there's not always clarity on these rights. And I think there's a more pressing need to look at how can we ensure that these people are, what I say, how can we see them? How can we bring them into a more formal system? It doesn't have to be a registration of a title deed in the deeds registry system, but maybe they can be something similar that's less cumbersome, that's more easy to transfer. And once you have that and people have secure tenure, that already goes a long way. People are not afraid then that they might be evicted or moved. They've got an asset that they might be able to leave to their children. The children might have a safe home. It might enable them, if that doesn't always happen or often happen, but it might enable them to upward mobility, to get a different place closer to their work, for instance. So I think upgrading of tenure there, that's a very big issue. And then, as I've said before, getting people access to housing, maybe in the form of rent, subsidized by government, closer to job opportunities.
Speaking about access to housing, it leads me to my next questions. So one of the challenges that are plaguing South Africa currently is the lack of access to adequate housing. As you alluded to, some people are staying in the backyard. Some people at some point in time they got evicted, so which is one of the biggest problems that the country is facing now. And this is particularly the problem for those people that are living in extreme conditions of poverty, homelessness, or intolerable housing. So how would the expropriation without compensation impact urban land use and access to adequate housing?
Yes, that's the million-dollar question, right? And I think part of what I was trying to explain during this whole process is expropriation is a very small step in all these things. My first question to people working specifically in housing is, what is adequate housing? What do we deem to be adequate? What is a dignified house? I know in the early 2000s, I don't know if many people know that, South Africa was lauded as having the best housing program in the world. We're very fast with these RDP type houses. What was deemed adequate was, I think, I'm speaking a little bit under correction, but I think it was 36 square meters, brick walls, sanitation within the house, at least 2 rooms. That was deemed adequate housing. So I think government needs to come up with what it deems to be adequate housing. So you have to start with a goal first. What is it that you want to reach? And then you take it from there. And where expropriation may come in this instance is if there is a piece of land that's either owned by the state-owned entities, as we've seen in the expropriation bill, but even, and I know here I venture onto dangerous or difficult territory, you do have people who still own large tracts of land, either on the peri-urban areas or in urban areas, that is holding onto the land in order for it to grow in its value, and then to just capitalize on that value. Maybe in those instances the government can say, listen, we need that land to build this adequate housing. It doesn't necessarily have to be at zero compensation. I know there are people that got very, strong feelings for these people that just hold on to land to capitalize on its value. But I think in many of those instances, government can say it is very important for us to have decent, adequate housing. We want to build houses and we need this piece of land. Can we please expropriate it? But with that said, government also has quite a lot of land that it can utilize. And so I think that's where the expropriation will come in. Expropriation, as I tried to explain during other conversations as well, is it's one of the tools in the toolbox of government to use to acquire the land in order to fulfill its constitutional duties. But I think we need to also understand, once the government has that land, they need to be clear what they are going to do with it, what are their views, who will, for instance, benefit from this adequate housing. That's also a very big problem in South Africa. How do you prioritize who must get the access to the housing? We have queues of people, but do we necessarily have to give the housing to the person that's in front of a queue? Or if there's a single or child-headed household that's in the back of the queue, can we prioritize that? And I think that's, for me, more important, where the conversation should focus.
Thank you so much, Elmien. I can see why this issue of expropriation of land is deemed to be one of the complex issues, and it makes me see that there's still a lot of conversations that we still need to have on this issue. It's the complexities are far from over. But as our last question, what are some of the practical and perhaps legal consideration that needs to be taken into account when considering expropriation without compensation, particularly in the cities?
Yes, so I think what came out, I have a wonderful colleague that works specifically on this aspect, Chantal Gladwin-Wood. I think she's doing a doctorate on some of these aspects. She also works a lot, she's a practicing attorney, so she works a lot with municipalities and rating issues. And I think one of the biggest fears at some stage was there was a version of the bill that allowed for the expropriation. So the national government can expropriate a building in a municipal area. Let's take an abandoned building for practical example. So there's an abandoned building. On those abandoned buildings, you often have really high outstanding rates and taxes, right? So normally if I want to purchase that building, I need to get a clearing certificate from the municipality that I cannot take ownership of that building unless the rates and taxes have been paid up. If the owner is AWOL, then normally the purchaser might need to step in there, or the municipality might otherwise lose out on a lot of revenue, right? So it's not fair of the city to have to bear that brunt as well. Although we can also have a long conversation about the collecting, but that's a totally different conversation. I don't want to sidestep that. So there was some sort of fear at some stage that if we allow for expropriation of these abandoned buildings at zero compensation, that the local government will lose that ability to try and collect the outstanding rates and taxes, because once you expropriate, you often get the building free of any burdens, right? So there's quite a lot of powers. And I must say we made this submission to Parliament on the previous version of the expropriation bill, and we raised this issue of, you need to look out for the revenue of local government, of the cities specifically. And, maybe you must say that there must be some compensation paid at least to enable that owner to pay for the outstanding rates and taxes in some or other way. And I must say, I really thought that the Department of Public Works that's responsible for the bill is quite responsive. And in response to that, they did change the next version of the bill to say that for purposes of the section, so that's municipal rates and taxes, if there are any outstanding municipal charges of the property, the expropriating authority must pay them out of the compensation money. And I thought, that's a protection for the municipality, which is quite important for sustainable cities as well. So I think that was some of our concerns, and that's been addressed to some extent.
Thank you so much, Prof. Elmien, for joining us today and for the interesting discussion on urban land and expropriation of land without compensation. I truly enjoyed the session, and I'm sure our listeners did too. To our audience, remember to like, to follow, share, and subscribe, and also interact with us and our guests on social media. You can continue the conversation with us and our guests on Twitter at ChatClass, or on our Facebook page at CLESTalk, as well as on LinkedIn at CLESTalk. Thank you for listening to CLESTalk, Law for Sustainable Cities, and look out for our next podcast.
Thank you very much.